did we go live? Damn it, the damn thing didn't work. Alright, I tried to do the live thing and it didn't click on, guys. Sorry. So I guess we're just live. Screw it. Hello. Hi, everybody. Yeah, we're starting things. Yes. Guys, tonight 11:30, we are going to do kind of a watch party for the Aussie Grand Prix. I figured out how to get some stuff to work. I mean, I hope Locals doesn't nuke it, but we'll try. So, Locals tonight, guys. 11:30. That's as late as we're going. So, otherwise, I was just going to stop and watch it on my own. So, hi, everybody. So, we're going to get started on this, and the problem is there's 147 pages. The last 12 are unreadable, and I think that's just the way things got scanned up. But I don't think we're going to get to finish it today. And I don't think we're going to get to finish it tomorrow just because there's so much and so much to look at here. But if you guys don't remember, Stephen Lorenzo was the guy, we talked about this earlier. He went ahead and ran around telling people and telling the judge, I want to be put to death. And the court's like, okay. Now, he's been fighting it because there's been an issue. He filed a motion fighting it. Now, why did he do this, you may ask? Well, there was some issue about the testimony that was coming in. So he's not objecting to everything, but he's just like, no, that's not fair. And it's rather hilarious what he's doing with this, because you're like, wait, why are we upset now? And you guys will understand once we get into it. Because you're like, what's the big fucking deal? You know, what's the deal here, man? So let's why did this not, I hate it when the thumbnails don't load. Because it's part of getting people's attention and they want to look at this and watch it. Sometimes YouTube, you make this too damn hard. Okay. So you guys remember we watched it earlier. He told everybody he wanted to be put to death. So he filed a motion with the court doing such a thing. And it's completely spastic. There's no other way to describe it, guys. It's exactly what you think it is. So here we go. Here is his motion. And we're going to start page 1. We're going to get as far as we can. Some of this we can breeze through. Some of it we can't. So we're starting off. In the 13th Circuit Judicial Court, Hillsborough County, he's captioned it all right. Okay, defendant's notice of mitigation and objections for court considerations at the sentencing hearing. And once we finish this, we'll listen to his sentencing hearing. His sentencing hearing is about 2 days long. Because remember, he pled guilty. But there's the guilt phase of a death penalty case, and then there's the penalty phase of a death penalty case, where the mitigation comes into play. So, just like before, Michael Burke says, motion granted, no oopsies, no takesy backsies. Yes. Brandon says, we can go to midnight. No, we can't, because I have to watch the race. So, no, we can't go till midnight, because the race starts. And you guys are saying turn up the volume. Volume is all the way up. I'll try to speak louder into the microphone, Pam. I'm sorry, but that's all I can do. So anyways, we're going to get started with this here. Wrong one. There we go. Okay. I am racist. Yes, I am a racist. I'm a big racist. I'm a big supporter of race and public racing. So now comes Stephen Lorenzo, sui juris, secured party creditor, third party intervener. The record holder in due course, all the stuff we talked about before, guys. The authorized personal representative and attorney, in fact, on behalf of the, what? Oh, hold on one second. You guys keep saying I'm quiet. Like, is this helping at all? Like, I don't know what the deal is. Like, it's live right now. I don't know. I'm trying to mess with it, guys. Is it all coming out, working? No, StreamYard's full tilt. Yeah, all caps cycle. Well, he writes in all caps, but is this loud, guys? Like, seriously, please don't fuck with me right now because I don't know what the deal is. I'm not worried about the mute. I know I'm not muted, but is it loud? It sounds fine. Okay. I don't know what the deal is then because this. I guess I'll turn it up in the mixer or something. I don't know if that's even gonna help, but you know, people are saying it's quiet, so I don't know what the deal is. Well, I can't get the mixer. Oh, hold on, the mixer's open here. Fine, let's see what's wrong. Like, I don't know if this. I'll turn it a little bit, see if that helps. I don't know. I don't know if this will help it either, but there, I guess it's a little better. I don't know. Let me know. So, I can hear you, but a little low. I don't know then, because I've got. Like, I'll turn it up on the mixer just like the last little bump. So, yeah. I don't know, guys. I don't know why it's not working. So, undo what I did. All right. Yeah, I don't know, guys. Don't touch. Well, don't touch it. Well, then people are saying there's problems. So, I don't know. Did I get struggling? No, it's just it's frustrating because some people are like, "Oh, this sounds good," and they're like, "Oh, it's bad." It's like, what the hell do I do? All right, don't touch the thing. Yeah, I know the audio is good when I don't lean back, but that's different. All right, so anyways, here we go. Let's go. Whatever. You guys can't hear. I guess turn up your volume more. All right. So yes, all the same nonsense from before. The third party creditor, the corporate fiction debtor, person legally known as the uppercase spelling of Stephen Lorenzo of the Stephen Lorenzo Cestui KV Trust, my commercial property, copyrighted. My commercial property as a non-person, non-fiction, non-subject, non-citizen, non-participant in any government programs, a living, breathing, flesh and blood private man standing on the ground, sovereign, gives my special visitation made by my absolute ministerial right to the state court pursuant to the federal rule AE as a restricted appearance, which you can do restricted limited appearances, but not in state courts. Hereby, something, this honorable court, and it's left out. I mean, maybe he says praise. This honorable court as follows. So he's invoking constitutional protections. He invokes his, claims each and every one of the protections afforded to him in his interest under the constitutions of both the United States and the state of Florida. So, this is the thing. Sovereign citizens all do their, some of them are, they think that the certain laws apply and they don't. And some of them they do. The rights known or unknown to him. So anything that I don't know, stated or unstated, anything I've said and not said. So all the protections, even the ones I haven't talked about, the ones I don't know about. To include, but not limited to, due process and equal protection. And then Article 1, Sections 2, 9, and 21 of the Constitution of the State of Florida. Nor shall any state deprive a person of life, liberty, or property without due process of law, nor deny any person within its jurisdiction equal protection law. Okay. And as you can see, guys, we got a long way to go. 2 of 147. But we'll survive. We'll survive, chat. We can make it till we can get far into this. Does that give me? I forgot how to make this full. There we go. Okay. So he talks about some criminal procedure here. The proceedings of issues on penalty, the order of the court in support of sentence of death. And these are all part of the, in Florida codified its criminal procedure rules. So it's under section 921.141. He's citing section 1, section 4, reviewing of judgment and sentence, aggravating factors, mitigating factors, and victim impact evidence. He also says the acceptance of a guilty plea or nolo contendere, that means no contest plea. You know, there's issues of plea about the voluntariness. Did the judge properly question him? And that's going to be normal. Do you understand what you're pleading to? Do you understand it's a full and complete admission? Acknowledgement by the defendant of being guilty. Do you understand your guilt? And we talked about that. Where he said, do you understand what's going on here? You know, was there a notice to seek the death penalty? Yes. He's citing all the relevant things. A pre-sentence report. The pre-sentence report when prepared. The pre-sentence report disclosure. The disclosure to the parties. And then the sentencing hearing. So we covered this part where he had the guilt phase where he entered a plea of guilty. And he pled guilty to 2 counts of capital murder. And that's what happened. Kind of like Nicholas Cruz. He pled guilty to 2 counts of capital murder and said, hey, look, I'll take my chances. So Brandon is a new member. Thank you for being a member, Brandon. I appreciate your support. Before the proceeding, the state of Florida distributed to all relevant parties its 4-page, with attachments, factual basis for the plea. The court allowed the state to read it in full in open court. The case, the factual basis that the state intended to prove beyond a reasonable doubt, and that's normal. Guys, when you have a plea, the state says, should this matter proceed to trial, the state would have been able to prove beyond a reasonable doubt that on or about such and such date at such and such time, you know, that Stephen Lorenzo did knowingly commit the crime of murder with, you know, malice aforethought and premeditation, and they would have gone through that. The state and the court were both, and that's how they proved the, you know, the factual basis read into the record to show that it was supported by evidence. Because the state still has, you know, the state still wants to be able to show that for the record. The state and the court were apprised that beforehand by the defendant, the fact that the defendant was going to plea out to his version of events that varied somewhat. And this is the thing here, guys. His issue is, yes, it all happened, but not like my co-defendant said. And I've had clients like this before. Yes, I'm guilty. Yes, I did it. And I agree I'm guilty. I want to enter a plea. But I didn't do it like they said I did it X, Y, and Z way. No, I did it A, B, C. Or I only did A and B. But A and B is enough. But I didn't do C. I'm not that bad of a guy. People really do this. They'll get it's sometimes it sounds dumb that you're gonna argue over how much of it you did. Like, I only stabbed him 10 times, not 25. But for people, it's like, they want to be held accountable for what they did and only what they did. And and when you have to think about it, it does make sense. It does make sense. Let's Go says the guy's handwriting is 10 times better than mine. Yes. So this is Alex, does this kind of shit work? I mean, to an extent it does. I hope you guys understand. Yes, when it comes down to a more basic level, I admit to a crime, fine. But I only want to admit to crime A. And crime A really did something. You know, crime A is enough. You know, you accuse me of all this other stuff. But I didn't do that. I only did A, not B and C. Reformed Convict says, I've been there. The charges didn't fit what I had done and was put in prison for. Well, in this case, though, he's just you'll understand, he's basically making the argument, I only stabbed him 10 times, not 25 times. And he's saying that the state doesn't exactly have the right kind of evidence or the right kind of disclosure. So that's what's happening here. Yes, I said 5 of 147. Yes. I mentioned that a little earlier, guys. That's no joke. He filed a 147-page motion. No joke. Now, his co-defendant also pled out, but he's not getting the death penalty because he agreed to testify. But once again, he's objecting to what his co-defendant says. He's saying that this guy's not true. And we'll learn about it because he explains in more intricate and detailed writing what happened that night. So, because we listened to it, and the judge is like, do you want me to tell you more? The judge is like, no. We're good. He writes out what happens. He literally writes out what happens. Claude says, I assume he's had a mental health eval? Yeah, all these guys do. Yes. Why did you self-delete if he requested the death penalty? Well, because I'm assuming he feels that that's not, whatever his belief system is doesn't reward suicide. And Alpha Fox is right. Yeah, basically he's saying, I'm only called him a nigga. I didn't use the hard R. And that's kind of what he's arguing here as well. So, Unhung Hero says, oh, I'm going to come. Delphi updates when? We'll be doing them this week. We've got, actually, I'm thinking this week because I'm thinking it sounds like some of the press is going to appeal the whole Judge Gull, because Judge Gull, spoiler alert, has denied all media coverage of the trial. So there won't be any media filming the trial. I think there's some press that are attacking that and challenging it, so we'll see what happens. Because I want to wait and see if those get filed. So we can talk about that this week. And Brandon says, I'm going to start a Where's Clyde fund for the stream. Well, if you heard him, he was click-clacking his way there. And Ag says, who gave this guy all this prison paper? He's entitled to the paper to write on. So, it looks like he tore up a legal pad and used this. So, yeah. So let's keep going here. Let's keep going. Shots. Yeah, Tilly, I hope you feel better, man. Please feel better. At least the indented is kind of justified. Yeah. Yep. Very true. This week is over. Okay, next week. So that's how I'm looking at it. All right, so we're going to keep going here. The defense informed the state and the court that for the most part, more than 90% of what the defendant was willing to plead to concurred with the factual basis just presented and read by the state. The court acknowledged that this was not unusual and proceeded to move forward, and that's true. After a second colloquy, Circuit Court Judge Christopher Sabella asked the defendant to describe his version of events that he was willing to plead to, starting with count 1. And that's which he did under oath in great detail. And if you guys remember, we listened to that. This was filed in the aftermath. He followed up a subsequent motion. Before the defendant, who was fully prepared to describe his version of events, was willing to plead to guilty as to count 2 of the charging instrument, Judge Sabella intervened before he had an opportunity to do so. The judge made it clear that he had found the defendant's version of events that he was willing to plead to out as to count 1 was as credible and aligned with what the state of Florida had just stated moments before. It was going to prove beyond a reasonable doubt. Without going at all into the defendant's version of what he was willing to plead to out regarding count 2, the judge fully accepted the defendant's both of the defendant's guilty pleas. And part of this is his issue. He's like, you didn't listen to me all the way. I want to tell you how they died. This is more of just like the Joker. Like, I want to tell you how they died. I want to go into graphic detail. So then he says, Honorable Judge Sabella immediately adjudicated the defendant guilty of capital murder. The state of Florida did not object to not hearing the defendant's versions of the events at count 2 of the state's charging instrument, thereby allowing unapproved the judge's acceptance of both guilty pleas based on only one of the counts. And that's part of his issue. Like, you didn't let me get to how the guys died in count 2, and then adjudicating the defendant's guilty of count 2 of capital murder. So he's bringing up some issues and problems he has. As promised by the defendant's version of events as to the charging instrument and the factual basis the state intended to prove, which included the necessary aggravators of the state in court, looking for match at about 90%. Notice what he's saying. I agree with you almost completely about what I did, but once again, this is I killed the guy with a fork instead of a spoon. That's basically what he's arguing here. This 10% difference. So, on December 6th, the judge then ordered, there was a pre-sentence investigation report, and then the adjudicated the defendant guilty to his voluntarily and fully knowledgeable capital felony guilty pleas to both counts 1 and 2 of the charging instrument. On December 13th, he met with the Department of Corrections official and a Tampa police detective so as to help assist in gathering the relevant information for the private and information necessarily required to be included in the pre-sentence investigation report. Now, why does this matter? So the pre-sentence investigation report, guys, we talked about this. It is what you use to give the judge an idea of who you are and what you do. Because he doesn't know anything about your case other than what's been stated on the record and what's in his file that's in front of him. So the PSI includes everything like your growing up, your mental health, what was it like growing up, your family life, going to school, how far you went in school, things like that. What's your education level, your mental health, substance abuse, your employment history. All the things you might want to have included and be able to tell the judge on a baseline, like, you know, have you been evaluated? Have you had this happen? Have you had that happen? You know, the story of you and how you got to here, your criminal record. And it's done well in advance so the PSI people can go out and verify. You sign releases. You know, that way you sign these special releases they have and they go up to your like medical provider and say, give me all his documents. He signed the release. And then they take him and put this report together. As one of the legal... And so he keeps going here. He's breaking these down by topic, which is actually very nice of him. Very organized, I will say. More organized than Russell Greer or Acerthorn, because if you guys are not aware, Acerthorn has sued Null and the Farms for copyright infringement. So, anyways, as one of the legal requirements to be included in the report, as are requested by the Florida Department of Corrections official firm to do, the defendant truthfully and completely expressed great detail both the events that actually did occur and that led up to the plea. Inclusive in the pre-sentence report will be found the factual and truthful detailed events by the defendant of what he pled guilty to that actually did occur regarding the death of Michael Waccholtz as part of count 2. Factually detailed events the defendant was unable and not given the opportunity by the court when he pled guilty. See pages 5 through 8 within. And isn't it nice? He can like fucking refer back and forth through his document. Like I said, this guy, like, I'll give him credit. This is well written. As far as the defendant is concerned and which he believes is legally correct, it is the defendant was still considered legally under court oath, not only when he expressed in great detail all the events that led up to the deaths of Jason Galehouse in count 1 and Michael Waccholtz in count 2, but to include any and all information he offered and expressed that would be all-inclusive and made legally a part of the pre-sentence investigation report itself. You're still not under oath, though. You can lie in a PSI. That's not a... you can lie on that. Never do it. Don't lie. Don't lie. I'm not encouraging you to lie, but you're not under oath at that point. You're no longer under oath. But notice he's saying, like, look, I believed I was still under oath. I gave you a heckin' true story. Trust me, guys. This is 100% true. So, Dolly, how you doing? Also, happy birthday ahead of time. I know it's still coming. Paralegal is hi. So, I I just did. Are you listening to me talk, sweetheart? Because I just said happy birthday, Dolly. Even though I know it's tomorrow. Okay, we're gonna keep going here. So, if the defendant is in error of his understanding regarding the legal matter, the defendant is willing to again be replaced, sworn under oath to satisfy any further legal necessities, especially as it pertains to expressing the truthful and actual events. So he's like, look, even if that wasn't correct, I'll come back under oath and I'll tell you everything that happened. It's almost like I want to tell you what happened. Like, I really, oh my God, guys, I want to tell you how these two guys died. And don't worry, we're going to get to that. He tells us how these guys died. The defendant was previously convicted of another capital felony involving the use or threatened use of violence to a person. The capital felony was especially heinous, atrocious, or cruel. The capital felony was a homicide and was committed in a cold and calculated, premeditated manner without any pretense of moral or legal justification. These are the state of Florida's aggravating factors, okay? He's not admitting to these. But look, he's got like 23 pages of this. So the capital felony was committed while the defendant engaged in the commission or attempt to commit sexual battery or kidnapping. See the state of Florida's notice of intent to seek the death penalty. And yeah, it's so interesting. Like, he does a good job. Like, I'm kind of impressed. Like I said, it's still impressive to see this. They also point out the defendant was previously convicted of another capital felony for a felony involving the use of threat or violence of another person. Once again, he's going back there. The state of Florida death penalty case stems from and is based directly off the defendant's January 2006 federal drug conviction. Yes. The state of Florida on this death penalty case is utilizing the exact same physical case discovery, evidence that the federal government utilized to obtain this 2006 conviction. And that's true. There's a separate conviction for this stuff. This state of Florida death penalty case is based specifically and only upon the deaths of Jason Galehouse and Michael Waccholtz, which the state contend occurred in December of 2003, over 2 years prior to his January 26, 2006 federal conviction. Prior to the deaths, the defendant had no previous criminal history whatsoever, nor had he even been arrested. Well, he went off the deep end then and went for the high score. I mean, that's interesting, I guess. Henceforth, the defendant at the time of both deaths had never been previously convicted of another capital felony. So he's arguing some of the points here, saying like, well, actually, yes, how did he get Sarah Boone to write this? Yes. I don't know what the state of Florida is, because remember, I can't get the case file open. So I'm not sure what he's making this argument about. I think he might be remember, he's probably misreading a little bit of this. So they're talking about the death penalty aggravators, and then, to secure death sentence adjudication upon the defendant, specifically and clearly, it states the defendant at the time had to have been previously convicted of another capital felony, not afterwards, which is clearly not the case in this situation. So, since the Florida statute does not legally apply, it would be a constitutional due process violation against the defendant for the state of Florida in this honorable court to utilize and or consider Florida statute 9.2114116B as an aggravating factor in this death penalty case. Now, that's funny, guys. He's eating away at some of these, and maybe that's true. I don't know his record, and maybe he's right, but he's still got a lot of other he's still got other aggravating factors, so it's not going to help him too much. The capital felony was committed while the defendant was engaged in the commission of, is this him admitting to it? Because the way this is written, the capital felony was committed. Oh, it's part 2. Yeah, I forgot how I read this earlier. So, 1. So he talks about was committed during sexual battery or kidnapping. So, both Jason Galehouse each, so he killed one guy, Jason Galehouse, first, and then Michael Waccholtz the second night. Each on separate evenings willingly came back to the defendant's house to engage in a sexual encounter and to also explore being submitted in a bondage situation. Here's where we get to, guys. If you're not prepared for this or you don't want to listen to this, this gets very baldo erotic very quickly. Very baldo erotic. And you've been warned. You've been warned. There we go. Hear the vacuum cleaner going. So, hold on. What's this? Lois, what's Lois? What are you asking? Lois says, "Can someone tell me why this is sealed?" I mean, it's an older case, too. I mean, it's been a couple of years. I don't know if all the records were put up. But no, this has nothing to do... The court down in Florida sealed it, so... Pacer has nothing to do with this, Carrie. It's just you can't open it. I think it's just because it's older. Pacer is easier to write off on taxes than a GT 500. It is, but Pacer, it's a state case. There's nothing to do with it. Yeah, but there's a lot of gay bondage murder coming up. So here we go. Oh boy, I've already read parts of this, and yeah, you're gonna listen to this. You're gonna say, "Oh, okay." You hear the 90%, then you hear the 10% of what actually happened, and you're gonna be like, "Okay, this is still fucked up." So Jason Galehouse, while also a willing participant in illegal drug use, allowed the defendant and 2 other bondage masters, plus the co-defendant, Scott Schweikert, because there were 4 guys there, 2 bondage masters and Scott Schweikert, according to him, and Jason Galehouse allowed them to submit and tie him to a bed so as to engage in a sexual bondage session encounter. Michael Waccholtz, while also willingly participating in illegal drug use, allowed the defendant and his co-defendant to submit him and bind him with straps on the living room floor so as to engage in sexual bondage encounters. So, the capital felony as it pertains to Jason Galehouse in count 1 did not occur while the defendant was engaged in the commission or the attempt to commit sexual battery or kidnapping. Nor was it ever the intention of the defendant at that particular time to do so. So, the capital felony as it pertains to Michael Waccholtz, count 2, did not occur while the defendant was engaging in the commission or attempt to commit sexual battery or kidnapping. Nor was it ever the intention of the defendant at that point to do so. Because remember, he didn't get to talk about part 2 in court. He had to say it in his PSI. And it's funny, he's already citing his PSI. But he doesn't have it yet, so he doesn't know the pages. Therefore, and due to the events that actually did occur on those 2 separate evenings in December 2003, and that's the thing, this occurred on 2 separate nights. Jason Galehouse was killed on one night, and then Michael Waccholtz was killed the second night. So, because he didn't do that, both of them, both their deaths do not meet and or fit the criteria definition to be legally utilized against the defendant as an aggravating factor. In this death penalty case, it would prove to be a due process violation to do so. He's saying, well, I didn't kidnap him. And we're going to read through this, and you're like, I don't think that's exactly the case, Tim. So, part 3. The capital felony was especially cruel, atrocious, or cruel. You're going to read this one, it's like, yeah. So, yes, he goes back to these two guys. Individually permitted themselves in some way or form to be bound and submitted to engage in a bondage session encounter. So it gets better here. So 4 other individuals, including 3, and he talks about Galehouse submitted and joined in the presence of 4 individuals, including 3 known and experienced bondage masters, including the defendant, and 1 inexperienced or novice dominant male, desiring to gain experience as to even eventually be a bondage master himself. Which, in this guy, was the co-defendant, Scott Schweikert. So, yes, he was under the tutelage of these 3 bondage masters. Like, I'm not fucking joking here, guys. I'm not fucking joking. This is real. This is real. Yes, a certified bondsman. Yes. Yes, it was an apprenticeship, Your Honor. Yes. He was my intern. He was my intern, Your Honor. Michael Waccholtz was knowingly did the same thing, but instead, in the second night, he only did so in the presence of only two other individuals, which included the defendant, who was known as an experienced bondage master, and the co-defendant, who was then a novice wannabe bondage master in training. He seems to be very mad at his friend. He seems to be very mad at his friend. Bro, you are very mad right now, but he wants to let you know he is an experienced bondage master. Meow. Come here, Chewy. The kitty's in here. In both separate evening encounters, the defendant's co-defendant, Scott Schweikert, the novice in training, he's so shitty about this, was given the opportunity to work on each of these submissive individuals so as to explore different techniques and to gain some bondage experience for himself. And each time he did, Scott Schweikert either lost control of himself or he greatly erred in what he was doing. I am not yet. Poor training turns you into a failure every time, yes. Sir San saying, can't the co-defendant blame him for being an insufficient trainer? Oh, that's great. That's great. On-the-job training is very important. Yes, it's important to have it. It's important to chat. Always have a good mentor. Always have a good mentor, no matter what it is you're doing. You're engaging in sadomasochism with random gay men in Tampa, Florida, or you're just learning any sort of hobby. Find a good mentor. It'll help you a lot. Oh, Brandon says, I'm going to say to where's Clyde Fund for the stream. Thank you. Patty for $4.99. Thank you, Patty. I know. I read through this earlier today, and I was like very speechless. I was like, what the fuck am I reading? Brandon for $5 says, where the heck is Clyde? Is he penning a motion to the ASPCA to be put down? Go stop him and force him on cam. Carrie says, what case did you not want to pay the pacer files for recently? Oh, for the Russell Greer case, because they're all available for free. Why would I do that? Why buy the milk when why buy the cow when you get the milk for free? So, yeah, I mean, why would I pay for all that if someone's already done it? Patty says their safe word is more. Yes. Yes, their safe word is Yes. Oh. Claude says, has he been sentenced? Yes, he has. He's already been sentenced to death. That's not the shocker. But he is appealing it now, and he's got attorneys helping him. And he goes, can you imagine how hard Regina's polo would be? Right now, he's listening to this. Access someone on the farms will buy it for you. They already posted on the farm. So, like, if somebody's already posted it, why would I do that if it's already there? And it's already available. Why would I waste, like, money at that point? It's literally free. People already have, like, grabbed them before I can grab them. Like, I'm not going to fight it. I'm just saying, guys, think about it. So, in each time, yeah, this is just... As it pertains to Jason Galehouse, count 1, who was willingly naked, bound to a bed, and spread eagle on a bed, wearing a gas mask, at his own request, so he wouldn't be recognized, while being videotaped by the defendant, while the other 2 bondage masters, the experienced bondage masters, looked on and stood off to the side so as not to be included in the videotape. Scott Schweikert was given his opportunity to show off some of his bondage techniques to the 3 present experienced bondage masters, with the understanding that the videotape was for the benefit of Scott Schweikert to help him critique his technique for improvements. It's literally fucking game film, guys. Hi. Hi, Clyde Bear. Hi, Papa. Yes, so... This guy's like Peyton Manning running fucking game film. Uh-oh. Yeah, I know. She's making you food, buddy. There's food. I know you want it. I got you. There. Yeah, you want it. Yep, it's feeding time. He's like, oh, I got food. But there you go, guys. This is just like the NFL. I need game film for later to break it down. Oh, God. Yes, gather around. I'm reading gay erotica tonight. Jesus. What is considered experienced here? I don't know what's experienced. That's part of the... That part makes me a little scared. Like, what do you consider experienced? But... Yes. His little paws clacking are cute. Yes. Is Clyde an experienced bondage master? I hope not. I hope not. I hope there's not dog bondage out there. Yes. Regulate the bondage market. Yes, we need bondage licensing. D.A. Val says, I regularly engage in bondage sessions in D.C., and this record is a cry for help or a serious problem. Oh, this guy's a complete lunatic, so yeah, don't worry. Don't worry. Yes. But yes, this is what pup bondage is real. Well, there's that, yes, but not... Yes, but I don't think Clyde knows anything about it. Access or bondage contracts legally binding? I mean, some of that stuff is binding, but you can't consent to, like, intentional acts of violence and stuff. And I mean, it's only binding to an extent. Like, it might show some consent, but those can, you'd be able to revoke those at any time. There's no way you'd be able to go to court and say, oh, look, they didn't want me to stop doing it. They said they signed this document. Like, no jury's going to buy your thing of like, oh, well, that means you can just keep doing it to somebody. So, you can't consent to a baldo. Yes, they are binding, just not legally. Yeah. Michelle says dog bondage? No, pup play. Like, they wear they wear dog masks and shit. It's a thing. So. Yeah, so, yes. So, let's keep going with the steamy details. Within about 10 minutes, Scott suddenly, without warning, lost control of himself and started to repeatedly punch the genitals of Jason Galehouse with his fist. Ow. Notice he's like, yes, this all didn't occur like you said. So, both the bondage masters and the defendant were shocked and outraged. The other two bondage masters immediately pulled Scott off of Mr. Galehouse, who was then in great pain. I'm sure he was. The defendant and both the other bondage masters were in great anger, fear, and distress. Everyone immediately knew with what had just occurred that a point of no return had already been reached. And a very quick and hasty, a not at all thought out desperate decision immediately made by all. A very quick and hasty and not at all thought out desperate decision was made. It should probably be a not at all thought out. He kind of messed up his commas there. Because it should be a not at all thought out, comma, desperate decision. Because that way the way you should be able to read that. And a very quick and hasty desperate decision was immediately made by all. So if you can read it without it, that's how that should be. But it's okay. It's okay. He's batting like 1,000 so far otherwise. But here's the thing. You can manifest intent in a second. It takes 1 second to manifest intent. And they manifested the intent to kill this guy. And also, look, he's tied up. And they don't let him go. That's kidnapping. He's being restrained in his liberty. Yes, this is why the Oxford comma is important. Juror 13 says, you were afraid of being convicted for, yes, ball punching, so they killed the guy and cut him up. Yes. Oh. Yes, it's the point of no return, so they had we've gone this far, so let's keep going. Brandon says, wait, is this gay bondage? Yes, it's gay bondage. Yes, fucking noobs, I know. Oh. I'm shocked and outraged. It's good to see you. Bondage masters need to requalify, yes. Oh, when slap and tickle goes too far, yes. Okay, we're going to keep going, though. In less than a minute, it was quickly determined that suffocation would be the most humane, if you want to call it that, way to do it. It would be done very quick and painlessly. It wasn't at all anyone's intention for Mr. Galehouse to needlessly suffer any more than he already had. Oh, you got, like, I don't get it, though. It's like, oh, it's like a horse. Like, oh, he broke his leg. We got to put him down. But this guy, it's like, oh, what happened? He got punched in the balls. Well, I guess, he's just like, if they had a gun, he'd been like, well, I guess we're going to put him down. Like, what the fuck? Although the suffocation thing, like, maybe Nick really is like this guy's spirit animal. The whole, like, suffocating raccoons. Maybe those raccoons got punched in the balls. The defendant and the other two bondage masters were so distraught and angry at Scott Schweikert for putting everyone in such a poor and untenable situation. Since Scott was so determined to prove himself worthy to be a bondage master, it was put on Mr. Schweikert to clean up the mess he created. All of it. And so he did. First with a pillow. Second, in the defendant's garage, with one of the other bondage masters who had some prior medical training with the dismemberment. While the defendant stayed in front with the second other bondage master for neighborly show purposes. And thirdly, with the same other bondage master in distributing the body parts. Because the other bondage master's vehicle was an open back pickup truck. This would account for no traces of blood to be found in the defendant's Jeep. This reads like my last high school paper. What the fuck kind of high school did you go to, buddy? Oh. Harry Stevens says neighborly show purposes. I guess to show the neighbors there are people still in the house. Like, and it doesn't get suspicious they all disappeared. Yes. Clean it up, Janny. Yeah, if you're the bondage master, you're the Janny now. Oh. Ben says, I think Nick wrote this. Yes. Charlie says, did this guy write 147-page letter to the judge? Yes. Yes, he did. Yes, he did. Brandon says, how do you go from stopping an assault to murder? Well, because apparently they're worried he was going to go to the police. So. He used his sack for a speed bag. So, yeah. He discussed in the plea hearing that if he had went into the garage to help, the neighbors would have come looking. Yeah. And it was all the neighborly purposes are to show people like are in the house and it's normal, everything's fine. So that's why he's like, but that's why you couldn't find traces of blood in my Jeep. As it pertains to count 2, Michael Waccholtz, he was bound hands and feet, fully clothed with different types of straps. Both the defendant and co-defendants were simultaneously giving bondage play attention to him as he lay face up on the living room floor, throw rugs of the defendant's house. So this is after they killed a guy one night. They're like, you know what? They're like, you know what, Scott? You know, I get it. Pre-game jitters, first time performing in front of an audience. You know what, Scott? Mulligan. We'll go pick up another guy and we'll try this again. After they'd already killed somebody the night before and cut him up. Like, double or nothing. Double or nothing. You're still eligible to get your journeyman's license. You're still eligible to get your journeyman's license here, apprentice. So, just prior to Michael Waccholtz being willingly bound, both Mr. Waccholtz and the defendants were consuming alcohol mixed drinks that the defendants had made them. Also, the defendant himself was also openly consuming, right in front of Mr. Waccholtz, crystal meth and GHB, which by at that time for the defendant had become a sad but everyday dangerous practice for him to do. With it understood that Scott Schweiker did not do illegal drugs himself. Well, isn't that refreshing? That your bondage master was only consuming alcohol, while the experienced guys were sitting there downing meth and roofies. Like, oh, this is just a normal thing every day. Just a bunch of crystal meth and a bunch of gays. Well, there's a lot of crystal meth in the gay community being used, but a bunch of GHB, crystal meth, and murder. Why not, chat? Why not? It makes sense, doesn't it? It doesn't it? This is yeah. Yeah, so I think this is Nick's memoirs, maybe. The guy stole Nick's memoirs. Yeah. I wonder if he called himself King Peg. Yes. That's James. It's always the meth. Yes, it's always the meth. He's saying, is this Chili with the GHB? Maybe. Maybe Chili did give him GHB. Chili is all on board with the GHB. Yes, he's feeding himself Cosby pills? No. Cosby did Quaaludes. Very different. Very different. Yes, and he's not smoking crack like Hunter Biden either, so. Mr. Waccholtz was offered a hit of both the crystal meth and GHB by the defendant in a spaced-out interval of, say, a 10-minute time frame. That's all. That's very generous of him. He's sharing, puff, puff, pass. Like, I get it. There's no bogarting here. There's no bogarting. Well, Stephen Lorenzo doesn't want to become, it's like, is William Holden here? I mean, William Holden, are you holding? He's not holding out on nobody. While the defendant and his co-defendant discussed how they planned to bind him, Waccholtz stated that he had used these illegal drugs a few times before in the past and agreed to party with the defendant, selling it to Mr. Waccholtz that the GHB would relax him and make the bondage experience more enjoyable, especially since it was his first time being bound. Okay. During the bondage session, which lasted no more than 20 minutes, well, there's a reason why it didn't last more than 20 minutes, chat, and we'll get to why that was. There's a reason why we only got 20 minutes into this. An inhalant was also given to Mr. Waccholtz by the defendant without Mr. Waccholtz's consent while he was being bound to help reduce his agitated state, which he fully addresses further on. I'm assuming that kind of gets you into kidnapping and unlawful restraint when you're forcibly drugging people up. And then for some reason they get rescanned differently. So we were at P. Elemental PQ. Q is for queer as fuck, because this gets really queer. About 10 minutes or so into the bondage session, I don't know if you guys can read it. Hold on here. Can you guys read that? Yeah, you still can. Yes, roofies. The defendant, Scott Schweikert, asked Mr. Waccholtz if he could expose his genitals to attach this metal sort of chastity device to Waccholtz's genitals, designed to bind and then encase them. It needs to be understood that the co-defendant has an affinity and a fetish regarding male genitalia, which the victim agreed to do. The bondage master, the defendant, did not intervene, since this sort of binding chastity device was typically and routinely used in many subcultures' bondage sessions. The binding metal device belonged to the defendant's co-defendant, Scott Schweikert, not the defendant. Why don't you just say it belonged to the co-defendant? Because we all know who he's talking about. As Scott Schweikert was attaching the device to Michael, he was having a bit of trouble making it fit properly. And it was becoming very uncomfortable and a bit painful to Waccholtz. And he expressed as much. Scott Schweikert assured Waccholtz that once the device was fully in place, it would be just fine without any pain. Claude's like, well, I'm out. Stabby says, no notification again. Well, don't worry, we're getting all the gayness. Oh, it's too opaque. All right, hold on, guys. It's too opaque here. How about that? How about that? That's got to be, hope that's a little better. Yeah, Waccholtz is packing, yes. Yeah, apparently his ball sack was too Scott isn't bondage material master after all. I know, that's the problem. Like, I hope the judge told him that. Sir, I don't think you're cut out for this. I just don't think this is you, sir. Okay. And he said, and I love how he speaks just matter-of-factly. It's just stream of consciousness. Well, this did not prove to be the case. Not at all. After that appeared that the co-defendant sort of had to squeeze Mr. Waccholtz's genitalia into the metal device just so it would fit, it became instead much more painful to Mr. Waccholtz. So it sounds like the victim was packing, packing some. He was packing, and he had a fucking mule, and it didn't fit into the cage right. It's like, wow, that's gotta hurt. As soon as the metal device was fully in place, Waccholtz started to squirm and raise his voice, and saying that the metal was cutting into his genitals and to get it off. As the victim continued to verbalize how painful it was, he also continued to squirm and jerk about in his bindings as he became more agitated. Immediately, the co-defendant attempted to remove the metal chastity device, and in doing so, whatever metal parts that were cutting into the guy's penis was being removed. It was cutting even in deeper, which caused even more pain, but also caused Waccholtz to jerk around on the floor even more rapidly. Ultimately, this made it even more difficult for Scott Schweiker to remove the genital device. Since Mr. Waccholtz did not realize that his jerking around and moving around on the floor were making it worse, was making it even worse, harder to remove the device, the defendant placed his hand over the mouth of the guy only for a second. So he would listen instead of making noise. He turned Mr. Waccholtz's head toward himself and told Waccholtz to stop jerking. Phrasing here, buddy, phrasing. Stop jerking and moving around so much that he was making it more difficult to remove the device. Waccholtz looked at the defendant as the defendant removed his hand when Waccholtz nodded that he understood. By that time, the victim was very agitated. And surely, you'd be agitated. Your balls are in a clamp. It's not fun. I bet it hurt. Yes, he's jerking. Yes. Oh, yeah. We almost need some, music in the background. Hold on here. Do we have appropriate music? We need some Nope. Nope, we don't have any appropriate music, guys. I'm sorry. Need some smooth jazz, yes. Steven says this is a metaphor for marriage. Oh. Yes. Yes. Waxing Miracle's right. Look, guys, we've all been there. We've all been there. Trying to take your chastity cage off of somebody who's got too big of a cock. Oh. End the stream. I'm almost sure we should do that at this point. Luke says the last one absolutely fits. The fuck you mean? Oh, yeah. Apparently it didn't fit well enough. But yes, if you can secure it, I mean, if it fits, it ships. So the victim calmly slowed down considerably. His jerking and moving about as he said, "Please hurry up." But within only a couple of seconds after doing so, Waccholtz unexpectedly and suddenly without warning ceased and stopped moving. Period. He stopped moving. Even before Scott Schweiker was even able to get the metal device removed fully. It became instantly clear. Yes. At that point, it was instantly clear to both the defendant that Mr. Waccholtz, to what happened he had just experienced. Both the defendant and co-defendant were completely shocked and absolutely stunned that there was yet again a second dead body laying right in front of them, literally within 2 consecutive evenings. Oh man, not again. Oh no! Who could have seen this? Oh no! Yes, who could have seen this coming? Yes, Scott, maybe beyond the baddies. Yes. How did this happen? How is this possible? 2 nights in a row, I've killed 2 gay men. How? Chat. Why, God? Why? Why are you letting these gay men die as I murder them and torture them? I'm sure that's not going to get clipped. Yes. Surprise Pikachu face. Torturing and murdering random gay men leads to their death. Huh? This sounds like a Mel Brooks screenplay, kind of. Oh. Oh, yes, that would be really good. Do you really want to hurt me? Yes. Yes. What are the odds? Yeah, it's like... They should have bought a fucking lottery ticket then. Oh. History doesn't repeat, but it quite frequently rhymes, yes. I know, third time's a charm. Third time's a charm. Yeah, you gotta go for a third time around, guys. Can't go 0 for 2. You gotta try. Go 1 and 3. It also became instantly clear to the defendant what had actually just occurred to Mr. Waccholtz. The combination of drugs and alcohol that was provided by the defendant proved to be a lethal combination for him. Or he suffocated him. I mean, the term is known as flatlining, yes, and is a common occurrence when mixing too many types of drugs, illegal or otherwise. Well, notice, remember, he said it was a 10-minute, like it was a 20-minute thing, and 10 minutes in, they put this thing on. So at some point, he probably had his hand over the guy's mouth for a couple of minutes. It was also, remember, he gave that guy an inhalant, which we don't know what it was. Probably like a whippet or something, maybe. I don't know. We don't know what it was against his consent. So it was later determined through the autopsy that he already had cocaine in his system, which the defendant did not give him, nor even have on him. Nor was the defendant even aware of this fact at the time. And notice, he's like making bullet points, so he's like part Z, and now he's on to AA. We're like into multiple things here. Henceforth, when you take into above account to include the defendant also using some chemical inhalants on Mr. Waccholtz without his consent, plus the agitated state Mr. Waccholtz was in at the time, it became obvious, without meaning, that the defendant had inadvertently overdosed him, causing him to perish. The defendant does not mutilate bodies. That's just not what he does. So after the defendant, not his co-defendant, who could care less, bathed Mr. Waccholtz to clean him up. You didn't do that to care for him. You did that to conceal evidence, probably. He was wrapped in a bedsheet, placed in the back of his own Jeep, and then transported to an apartment complex parking lot and left there. This would account for the difference in how in each victim was dispensed with. Could this victim have had a funnier name, Waccholtz? I don't know. Don't the gays like to inhale poppers? I think some do, but it's not clear what it was. Patty says, were the other 2 BMs there on day 2? No, I think once they realize, like, so you committed a death, they're like, yeah, we're out, buddy. Good luck. They're like, good luck on your future endeavors, sir. Yeah. Nick definitely wrote this. Jesus. So, I mean, it sounds like kidnapping to me because they wouldn't let him go. All capital felonies, regardless of the circumstances, would in some manner or form be legally considered heinous or atrocious or cruel, no exception. This is pretty fucking heinous and cruel. For a capital felony, the death penalty aggravator to be legally considered especially heinous or atrocious or cruel, the perpetrators would have to have gone out of their way to make sure the victim suffered a prolonged or agonized death, such as burying them alive, leaving them out in below temperatures, to slowly freeze to death. That's not going to happen in Florida, so how is that a standard you're using? Or even stabbing them up and letting them slowly die by bleeding out. In this particular capital felony, the case just the opposite has actually occurred. As it pertains to Mr. Galehouse, not one of the four perpetrators wanted nor intended for Mr. Galehouse to suffer any more than he already had. So the perpetrators specifically chose suffocation as the method to be used, which would have been a painless and quick for Mr. Galehouse. I don't know if you guys have ever been in a situation before where you're not able to breathe, like you've either been choking or stuck in somewhere where you can't breathe or something happens. It's not painless. It's scary as fuck. As it pertains to Mr. Waccholtz, this aggravator doesn't apply since the death was not at all intentional, according to you. Although, to be fair, who would admit that, yeah, we were doing all this freaky deaky gay shit and then he died? That gives him a little, I'd argue that gives him a little bit of credibility. He's willing to admit to all this. It's why would you say this if it were not true? Holy Jesus. He was in jail last I checked. Yeah, he's still in jail. Oh. Oh, Patty says the dog's name is Roman. He says hi. Well. Yes. Content Lasagna is right. Dun, dun, dun. Is this due to soft sit? Yes. Yes. Yes, he's a soft sit because we're on page 33. When you go all the way up to page 1, remember, he does all this, secured party creditor, lawfully authorized personal representative attorney, in fact. All this shit right here, this is all sovereign citizen nutbaggery. So, yeah, yeah. So, yes, it's very funny how he's actually... I didn't do it. Who's removing comments? That's going to be YouTube if the comments are getting removed because the mods don't remove comments. I don't remove comments. No one removes comments. So unless they're removing their own comment, that's the only other way. So let's keep going, chat. Let's keep going. The term especially is legally ambiguous. And as far as the defendant is concerned, is constitutionally deficient and illegal. Simply because it is left to an individual who owns individual's own personal interpretation of what they would each consider to be especially heinous, atrocious, or cruel to themselves. Since it's impossible for this aggravator to be legally applied in a uniform or equal manner when used in enhancing a person's death sentence to death, that it would automatically be a constitutional due process violation. Should the state of Florida or this honorable court choose to utilize this aggravator to enhance the defendant's sentence to death, when it is legally impossible for the state to prove unequivocally either way, or otherwise to what the defendant under sworn oath stated and testified to what actually did occur on those 2 winter evenings, the defendant considers this to be constitutional deficiency and due process rights violation against the defendant that should be reviewed and addressed by the Florida Supreme Court. Okay. So now we got through all of his objections and reasonings. So his mitigation factors. He has no, notice he's saying significant, which means he does have a history of prior criminal activity. Before he said he had no criminal history, but he does have prior criminal history. Okay. But he has no major crimes. The victims were a participant in the defendant's conduct or consented to the act. I mean, partially, but they asked to be released and you didn't let them. So, I'd argue they no longer were consenting at that point. The defendant was an accomplice in the capital felony committed by another, and his or her participation was relatively minor. Relatively minor participation. Relatively minor. Holy Jesus, guys. Stabby says, I'll only your comment if you're trying to dox someone. Be as racist as you want. I get to be the R in the tower, though. Fair enough. Fair man. Fair man. Jason Lazat says, for $5, a little something for the entertainment. I feel a bit dirty and I think I need a shower. I'm not sure why. Well, yeah, imagine reading this a second time. Like, I'm voluntarily reading this again. The defendant acted under extreme duress or under the substantial domination of another person. Who told him? He doesn't say that happened up above. He doesn't go through this and say, Swiker told me do it or I'll kill you. He doesn't say he was ordered to do something. None of that. None of that occurred. There's no proof any of that happened. The existence of any other factor in the defendant's background that would mitigate against the imposition of the death penalty. So, the defendant has no significant history. The state of Florida death penalty case is based directly on the January 2006 federal drug convictions, which those are not significant. I don't know if how they're not significant. The state of Florida is using the exact same physical case discovery evidence the defendant had in that case. And he's kind of rehashing some of what he's already written, and that's a problem with these guys. They're rewriting some of this stuff here, okay? So, the state of Florida death penalty, is based on the deaths of both Jason Galehouse and Michael Waccholtz. And they occurred in December 2003, over 2 years prior to the defendant's January 2006 federal conviction. Prior to the deaths, the defendant had no previous criminal history. Yeah, okay. Nor he'd ever been arrested. I doubt that. He had no criminal history activity prior to this. Period. So, he keeps on restating it. The mitigator under the statute's adjudication states that the defendant at the time of the deaths needed to have no significant history of prior criminal activity, not afterwards, which is exactly the case in this matter. I think he might be misreading the way things were typed up by the state, but who knows? Who knows? It doesn't really know. We don't really know. And since Florida does legally apply the Florida statutes apply in the circumstance, it would be a due process violation to keep doing it. And or consider that use it as a mitigating circumstance in his death. Okay. The victim was a participant in the defendant's conduct or consented to the act. As it pertains, they were both willing participants in a dom sub bondage submission session with the defendant. In both instances, each victim was a participant in the defendant's conduct or sentenced to the act or consented to the act. But each victim willingly placed themselves in harm's way by allowing themselves to be isolated, bound, submitted, and left completely vulnerable by multiple subculture bondage masters, including the defendant, that they did not know prior and which they had just met in a nightclub subculture leather type bar just an hour or two earlier. Yes, it's their fault, chat. Chat, it's their fault. It's their fault they did this. It's their fault, chat. Chat. It's their fault. I mean, to be fair, yeah, you don't go with random guys and leave a bondage bar and then like, oh, I'll go do bondage at some random house. Generally an idea, but yeah. Yeah. Yes, more bondage, more bondage. More bondage, chat. More. 1,000 likes and Tilly will ban me. Can we meet the goal, chat? Praise the goal. God bless the goal. 1,000 likes, chat. Let's do it. Oh, my God. This is just too fucking... Like I said, I hope you guys are enjoying this because this was so hilarious to read earlier. In both instances, unexpected and unplanned situations occurred that went terribly wrong that ultimately regrettably cost each victim their lives. No matter how you look at it, some personal responsibility has to be taken by the victims themselves. They each took a chance and participated in something they did not fully understand or give much thought to, without realizing that it's not so uncommon for things to sometimes go unexpectedly very wrong when in a sadomasochist type subculture bondage experience. Nope. Hey guys, you assume the risk. It's just like going crab fishing in Alaska. You know, sometimes you get hauled off the side when the rope wraps around your foot and drags you to the bottom. Oh well. As it pertains in particular to Michael Waccholtz account 2, the defendant believes without the intention of doing so from an overdose of a lethal combination of drugs plus alcohol mostly supplied to him by the defendant, it is legally not considered a capital felony but actually falls under the legal category of murder in the second degree and constitutes a felony in the first degree since it was without any premeditation or premeditated design. Therefore, since Florida statutes do legally apply this circumstance, it would be a due process violation in this death penalty case. That the defendant was an accomplice and his or her participation was relatively minor. As it pertains to count 1, and actual events that took place that evening, it was the defendant's co-defendant who lost control of himself, which had now created and set the stage, so to speak, that ultimately became the main determiner for the death of Mr. Galehouse. Since the co-defendant created the ultimate untenable situation to begin with, the responsibility was placed on the co-defendant to handle it himself completely, which he did. This resulted in the defendant and in the co-defendant, not the defendant himself, who actually committed the capital felony, which was then against him by through suffocation, then dismembering and dispersion of the body and body parts, with one of the other bondage masters who were present at the time. Oh, fucking believe this guy. Oh. Even though the defendant had a relatively short time frame opportunity to intervene to stop the capital felony itself from occurring, he did not out of concern and worry for his own well-being and future life endeavors. Other than this, the defendant played no role whatsoever in the commission of the capital felony and beyond. But you did, though. You literally did. You literally were involved. You helped plan it. You said, I guess we're going to kill him. Sure. I mean, you guys all said you were going to do this. So that's a conspiracy to commit murder. You guys all agree it's going to happen. Therefore, since Florida statute doesn't apply, to some degree in this circumstance, it would be a due process violation, according to him. He acted under extreme duress and substantial domination of another person. Okay, so as it pertains to the first guy who got chopped up, the surprising circumstance is when the co-defendant lost control of himself. Remember, he keeps on now. He talks about this guy was a willing bondage session. Was not only very unexpected but very concerning, and felt by all at the time anyway, not only to be a very dire situation, but a situation that had only one viable solution, a solution that needed to be rectified without haste. Please note the defendant is not justifying the actions that did occur on that winter evening in December 2003. For truly they aren't anyway, but being there and at the time anyway, all four of the individuals present, including the defendant, were extremely concerned and upset as to what might happen to each of them, including the defendant. So a quick decision was hastily made within a minute or two. It was a rash, regrettable, and not at all very well thought out decision. Made under pressure that was also felt at the time required immediate attention. A rash decision by itself, which proved to be a very fateful one. Now, I think he's making, the argument here is that it's duress, but it's duress because of the situation. And it's like, that's not how it works. The idea of getting caught is not, you can't use that as duress. It's do it or I'll kill you. Help me or I'll kill you. Yeah. So, once again, he's arguing this would be a due process violation, which, I don't know. I don't know, Tim. I don't think so, Tim. That's what I think here. Oh, my God. Chat. Shiatsus. So this is just, it's just, oh my God. Oh, sorry. Somebody sent me a message. I had to read it real quick. So because of all that, it is a due process violation. The existence of any other factors in his background that would mitigate against the imposition of the death penalty. And here's the thing, guys. Going back to this duress real quick, nobody forced him. He's just saying the duress of the situation. That's not a effective answer. This mitigation circumstance is already in process and by and through the defendant's own 39 handwritten page mitigation letter. I don't have that. We're going to have to, and I don't know where to get it. I'm going to have to contact the court, see if I can get it. So he's basically saying, see other document. So he points out, what are some other objections? There are more objections here, guys. The co-defendant's testimony at the sentencing hearing. The defendant pleading guilty to 2 counts of capital murder based solely and only on his own factual version of events that had occurred, not his co-defendant's version. Remember, this guy is so wrapped around the axle, he's trying to say, look, everything you guys are saying is almost true, but the last little bit is my correct version of the events. I didn't stab him. I just held him down while somebody stabbed him. You know, that's how this guy wants to split hairs, which just shows you how much of a lunatic he is. And also, hold on one second, everybody. All right, we're back. These two guys backdoors couldn't just take a fun game of catch. Oh. You guys can't chalk this up to Coof. These aren't COVID chat. These are not COVID. Chat, these are not COVID-related deaths. We can't make that argument. This is 15 years. This is almost 20 years too early, chat. It doesn't work. It does not work that way. Anytime someone's died, you can't go, well, guys, I guess all those deaths at Birkenau, you know what? Guess they're COVID-related. You know, they were unvaxxed. You can't do, well, as much as you would like to do that, you can't. Tell that to the CDC. Yes. Trust the science. Oy vey. He had a gas mask on. I know. Better than N95. Oh, my gosh. Oh. There were no Treblinken vaxxers. Yes. Oh. Chili says, oy vades. Oh, god damn, that's a good one. Oh. Patty says, what happened to the video? I'm sure the video is recorded somewhere. We didn't get to see it. I'm not sure I want to watch it. Watch some random twink get his balls punched. Doesn't sound like fun. So. The co-defendant's version of the events was never taken into account by the court, nor considered, nor made part of any guilty plea at all when the circuit court accepted both of the defendant's guilty pleas. Should the state of Florida or this honorable court choose to utilize the defendant's co-defendant's version of events, contrary to the defendant's court-accepted guilty plea version on this death penalty case, the defense considers this to be a constitutional deficiency and procedural error that should be revised and addressed by the Florida Supreme Court. So he's saying, look, I've already pled out. I've admitted to this. If you bring him on, guess what I'm doing? I'm going to appeal, chat. So, constitutionally and legally, defendant can only plead guilty to a crime based upon the facts as he knows them to be, not someone else's version of events. Should they prove to be different. For a defendant to otherwise, the court would legally consider this committing perjury. Courts don't really care if people commit perjury. They let cops do it all the time. Once this honorable court accepted both the defendant's guilty pleas to count 1 and 2 on this death penalty case, it legally and constitutionally accepted only what the defendant knows to be a truth of the actual event, not the defendant's co-defendant or any other person's version of events. I mean, yes, that's what I get what he's trying to argue here, but they're allowed to bring in other evidence and other accounts of what happened for the penalty phase. Because remember, you're already past that. Now you're assessing the penalty. So, even though at the time the court heard under sworn oath testimony by the defendant of count 1, The court found the defendant's version credible, knowledgeable, and factual. In doing so, the defendant's version of events constitutionally now becomes a legally accepted version for sentencing purposes. Under this death penalty case, how could it be constitutionally and legally not be? What a crazy man. What a crazy man. Holy cow. Hold on one second. So for the state of Florida now to come along after the fact of the defendant's own sworn under oath factual basis of events that actually did occur by introducing the co-defendant's unprovable word against my word. Once again, he's very upset about this. And this is the delusion here. This is I'm not a scientist, yes. Yes, here's the Soviet sit coming out. So this is him starting to lose it. This guy's patient zero, yeah. So they're using the co-defendant's testimony in an attempt to enhance the defendant's role in a capital crime well over and above what the defendant knows them to be. And he's trying to make this argument by saying, look, you guys are making this worse, and I really haven't, committed all this. But it's weird, though, because he says he wants to get the death penalty. So why is he fucking arguing about it? Well, he's saying, remember, like I said, some people are like, look, I did all of that, but I only did it on my terms, not your story. Your terms are not correct. So that's how these guys get a little weird with stuff. To do so would not only violate the guilty pleas themselves, but would also be a gross violation of due process. Please take note. In this particular situation, not counting the other two persons who can no longer be located, the other two, and that's the thing, these two bondage masters, I don't think were ever caught. The only two witnesses to the events of this capital death penalty case would be the defendant himself and his co-defendant. Each with those two different versions of events themselves, but also two different versions of the role each person played in the crime itself. It is the responsibility of the state of Florida to introduce evidence, especially evidence with the intent and purpose of enhancing the defendant's role in a capital crime, so as to bring forth the death sentence upon the defendant only, when they know that it can be proven beyond a reasonable doubt the claims they are making. The physical evidence that the state of Florida currently does have on this defendant, on this death penalty case, regarding what actually transpired on those two separate evenings, and exactly what each person played in the actual deaths for both counts, does not in any way point to either the defendant nor his co-defendant in particular. None whatsoever. I mean, he's saying there's no proof. Like, there's nothing. I mean, you're admitting to it, man. I mean, you're admitting to it. Homie, you're admitting to this shit. You are admitting to. Somebody says try pink. All right, we'll try pink here. Here, we'll try that. It's a little different color. So instead, the state of Florida attempts to introduce ambiguous my word against your word on provable evidence at a death penalty sentencing hearing, specifically for the purpose of enhancing the defendant's sentence to death, with fully understood that the state of Florida has already been given 80 to 90% of its case factually basis evidence and aggravators on both counts 1 and 2 that were admitted by the defendant already. Yeah, and now this letter, I would argue, is probably 90%, because any, like the other 10%, you've argued all the issues there. Oh, thank you. Uh, Therefore, since the state of Florida is fully aware that it can never know for sure, and that it is impossible for them to prove beyond a reasonable doubt what actually transpired and did occur those two separate winter evenings, and what role in particular each person played in both deaths. You literally just told us, though. Um, I mean, the two bondage masters were the booty bandits. Yes. Yes, that's what they were. Oh. Other than what he said, she said, then it is not only responsible and illegal for them to introduce such ambiguous and unprovable contrary accusations, but it would also be a constitutional due process violation to do it. Testimony of any of the victims of the defendant's 2006 drug sentencing. The state of Florida is based specifically on and only upon the death of both Jason Galehouse and Michael Waccholtz, which occurred in the state of Florida, contends occurred in December of 2003, over 2 years prior to the January 2006 federal drug conviction. Prior to the deaths in December, the defendant had no previous criminal history whatsoever, nor had he even been arrested. Henceforth, the defendant at the time of both deaths did not have what would be legally recognized as victims of the defendant. None whatsoever. I find that hard to believe you had no victims. I find that really hard to believe. This legal fact came only into legal existence over 2 years afterwards, and or after the fact once and only when the defendant was federally convicted in January 2006, not before. Therefore, should the state of Florida bring this all up and hold the defendant accountable for something that did not legally exist in December of 2003, enhancing the sentence, this will be it would be a constitutional ex post facto violation. It's not that's not the real meaning of ex post facto, but yes, you're applying a subsequent conviction to prior conduct, which that would be the argument he needs to make, and I don't know why he's making that argument. That's just kind of weird. But I get what he's trying to say. You're using subsequent conduct to punish me for a prior act, which doesn't make sense. And I doubt that's the situation here. I just don't think he's read the state's motion right. Okay. Now he's arguing about any and all of the defendant's personal computer pictures presented at sentencing hearing, unless the state of Florida can first legally validate and completely exactly what each picture is actually depicting. As part of the case discovery in this case, can literally be found a few 100,000 plus digital pictures taken from both hard drives of the defendant's personal computer, where in all actuality, tens of thousands of those digital pictures depict men in various situations of sadomasochist bondage, submission, and depraved scenarios, to include multiple digital video clips of the same, and which the defendant downloaded from the internet. Also to be found on both hard drives. So he's got, what about the gay porn? He's got a lot of gay porn, apparently. He's a connoisseur of it. Also to be found on both hard drives are multiple hundreds of digital pictures that the defendant himself took of men depicted in various positions and in situations of sadomasochist bondage, submission, and depraved torture scenarios. The scenarios of sadomasochist bondage torture scenes, the defendant personally set himself up as an experienced bondage master. Oh, my God, this is just... Isn't this great, guys? Like, I read this earlier, and I'm like, you guys are going to fucking love this. Brandon said, I like the yellow highlighting. I thought you guys could read it. You should have said something. His butthole looking like a roast beef sandwich is proof enough to me. Yes. Do bondage masters have a union? I don't know. So. Yes. He's an artiste. Yes. He's an artiste. This should be a movie. Well, there are movies. Just, oh, you mean like this whole thing is a movie? Okay. To add to all of this as part of the case discovery, evidence can also be found in multiple thousands of pages of America Online real-time computer chats where the defendant had literally multiple hundreds of other individuals who were into being bound, submitted, and or tortured, who oftentimes requested the defendants do to them what would be considered by most of society as being depraved, sick, or disgusting, including, in law enforcement, the state's attorney's office, and this honorable court. Dozens of those chats, and others elsewhere who lived mostly, like I think he means chatters, who mostly lived in the Tampa Bay area, and the defendant, many dozens, met the defendant willingly to submit to some very depraved situations and scenes to which the defendant was more than pleased to do so as a bondage master. Remember, guys, he is a bondage master. You know, he's the only one professional enough to be doing this, not you. As the vast majority of the defendant's personal bondage submission pictures of others do appear to be grossly depraved and are themselves to everyone and anyone who is not understanding of the subculture. Yeah. Probably a bit. So those are not into the... It's subtle cues, you guys. If you didn't understand these, if you weren't retarded, you would understand this. You would appreciate this art, chat. To those who are not into the culture, each and every person depicted would automatically appear to be a victim of the defendant, especially to the state and everyone else watching. Not even close. Not even close, chat. Not even close. You can't use master. It's racist. He's a senior bondage advisor. So, when will the jailhouse findings from Chile to Castro be available? Does Nevada post them? I hope. I don't know. We'll find out what's going on, but I don't know yet. We'll take a look. This is just, I love it. I read this earlier and I'm like, he's just like, y'all don't understand. We're going to get a certified bondage master. Yes, now he's just coom posting. I know. He's just cooming. Since virtually every picture of the defendants is being misidentified and or completely misconstrued by others, It now becomes a constitutionally legal responsibility for the state of Florida to completely and fully legally validate each and every one of the defendant's personal bondage pictures before they be allowed by this honorable court to be presented. I think that's fair. That's actually a fair argument to make. All these pictures, well, you should present ones you can only prove that are violent, because some of it that is the thing with some of this bondage stuff, like people getting hit, people getting, like, they're saying no, or they're against their will, they're chained up. Well, you can't just say, oh, these people are victims, because how do you know? Like, they have to be able to prove that. If they can't, that's unproven evidence. So, like, he doesn't have a right to challenge that. And at a mitigation hearing, he does, like, the rules of everything still apply. So all your constitutional protections are still in place. Remember, you have to be found beyond a reasonable doubt that you need the death penalty as well. Now, that's saying he's aware there's a low threshold necessary to validate a photograph. The only way the Florida can legally do it is to meet the threshold as follows. Now, this is not, like, he's right, though. Like, he's right to say that the person in the photograph is able to testify and confirm, not only prove that it is them, but validate and confirm what's going on. Someone who is present when the photograph is taken can testify in court and confirm what the state is claiming. Yeah, the photographer themselves, who is present at the time, can testify in court. Yeah, there's ways you can prove it. I would argue it is probably unconstitutional to say that these are all, because it is questionable, but it's rather unsavory looking. Like, yeah, it's probably gross and freaky deaky, but he is right to argue that's not fair. So, yeah, this is. So, once again, he gets through all this, that these would be due process violations. And it's unfair that he has not a chance to contest these and legally validate them. That any unvalidated photographs not be allowed in, because it would be a due process violation. And I think that's a fair argument. So, he's arguing against any attempt by the state of Florida to try to reprove or re-go over or rehash at the sentencing hearing what the defendant already pled out to under sworn oath. Now, he says, in reading over the state of Florida's basis for the plea, it is clear to see that what the defendant pled out to and admitted under sworn oath at the same court hearing to now also include the December 13th pre-sentence investigation report. Remember, he still thinks that's sworn testimony. And this present defense notice, see pages 18 through 34 within. I fucking love this guy. I fucking love all this. Matched and concurred legally proved itself by at least 90% to the state of Florida's factual basis for the pleas. Therefore, the defense is requesting of this honorable court to not allow the state of Florida to try to reprove anything that is legally unnecessary, irrelevant, or redundant that no longer needs to be proven, since it has already been validated or admitted by the defendant. The defense has no issue with the state presenting in court whatever relevant evidence is necessary to further prove its case. They have every right to do so, but the defendant does have a legal issue with the state of Florida should they attempt to present unnecessary, redundant, or already proven evidence to further induce or prejudice this honorable court at the sentencing hearing. He's saying you can't redo it. Anything else you want to present, well, present. But he's like, also, not all that other stuff I just said. Yeah. Yeah. Oh. So, now we're getting into ex post facto laws. Ex post facto, legal definition after the fact, that's close enough. Prohibitive laws. So, let's see what he's going to argue. He argues constitutionally, this literally and legally means that it's unconstitutional for any form of government, federal or state, to pass any laws that could be used against someone and which could be used to hold a person legally accountable for reasons responsible or something of a legal nature that occurred afterwards or after the fact. In the same vein, it is equally unconstitutional for any form of government, whether it be legal or state, to utilize anything of a legal nature against someone that occurred afterwards and or after the fact. This would also include the defendants now legally considered after the fact. State of Florida's claim to having a criminal history. But you do have a criminal history. You have a criminal history that precedes this trial, precedes your indictment. Your charges were filed in 2016. So yes, you do have a prior criminal history. Now, there's a distinction. You can make the argument these occurred after the alleged facts, but you do have a prior criminal history, dude. It doesn't work that way. Like, you can make the distinction, but it doesn't really make you look any better. Also, remember, he's doing 200 years in federal prison, so it doesn't really matter what happens to him. So, I understand what he's trying to argue here, but this doesn't matter. This is all argument that doesn't really matter. Like, you do have a criminal history. Because you could almost argue after you committed these murders, you went out and committed more crimes. That's not a good look either. Like, it's like, I only committed these crimes after the murders, so I'm not as bad. It's like, that makes you look really bad. I mean, it's not a good argument. Brandon says, you can't prove these guys didn't like it. They like butt stuff. And Pike says, how do you underwrite the bond of a bondage master? I don't know who does. That's a good question. So we're going to keep going. Hi, Clyde. Here. You want a treat, Bubber? Here you go, buddy. Okay. So him arguing about all the stuff that happened after the fact, it's like, after the deaths, it doesn't really matter, man. It does, like, you have a criminal history. And this one I think is completely, like, he's just misunderstanding things. Arguing about his sentencing, that he has a criminal record and criminal history, and that the defendant presently has legal victims. They wouldn't be committing an ex post facto violation, so that one's completely stupid. I mean, all this is just nonsense to an extent, but that one's completely like, he's just not, he is literally not understanding what we're talking about. So. Should this honorable court allow all this, it'll be a due process violation. Except it's not going to be, buddy. It's not. Like, this is all garbage. Should the court choose to, utilize deny him his right as a prior mitigating circumstance, this court would be committing an ex post facto constitutional due process violation. That's not no. No, that's not right. That's not how that works, buddy. Please note, this is the reason that they specifically use the word prior within them to meet the ex post facto constitutional mandate. Yeah, it's not. You're not. So he's like, the credibility of the witnesses. Well, you're already done, man. So there's testimony from the co-defendant, the federal grand jury testimony, 72-page transcript, which we don't have. We'll never get. Interview with the Tampa police in May of 2005. State of Florida's Proffer. Yes. All this was under sworn oath. Under sworn oath. So, the credibility of the state's witness. So there were the second state of Florida proffer. It looks like there were some proffers by this guy. He had a third proffer, which isn't abnormal, because it looks like he gave multiple ones. He gave one in March 2015, September 2015, and his plea agreement. So, excerpts from the factual basis. So, this guy just fucking goes on and on and on, chat. He's a machine. Although, actually, we need to see how long Schweikert's going to prison for. I'm pretty sure he got life, but there's no, there's nothing here showing that. So, and actually, guys, I need to go get a drink because I am out of water. So, I'm going to be right back because I need something to fill this up with. So, we'll be right back, guys. Hold on 1 minute here. Your Honor, half the witnesses were lying to get more sick. It's an interesting choice of words, Sean, calling up a machine. I mean, basically is. I wish Alyssa was here, yeah. I'll tell her to watch this. There's some good stuff in here. Can you imagine the detective having looked at this guy's computer? Yeah. No. Brandon saying in a White Claw, yeah, I had my fun last night, so I don't need more fight. So, don't need any more. I'll be right back, guys. Give me 1 second. That's a really good question. I should have done that. Good idea. So that's a really good idea, Green Caps. I'll do that in the future. Nika says the tower is covered in thermite paint. And it fell over, yes. Oh no, you guys started something. And then no. Didn't get off the ground right. Barely got going. That's in the chat. So, all right, guys, let's keep. We're gonna go till about 11 or so, guys. I'm gonna see how far we can get into this, but, yeah. So, Schweikert initially denied participating in any forced physical contact with Jason Galehouse and denied any knowledge of the circumstances surrounding the disappearance. He initially denied being with the defendant that night that the second guy, Waccholtz, went missing. Schweikert initially denied knowing about the death of Michael Waccholtz. Well, I don't get, and I read through this earlier, but like he's just basically, he's rehashing arguments of things that occurred. Saying, well, this guy gave inconsistent statements. Like, yeah, what he said, like, yeah, initially you lied to the cops. I'm sure you lied to the cops too, Broheim. So, in subsequent statements, Schweikert admitted to participating in the killing of both and disposal of the bodies of Jason Galehouse and Michael Waccholtz. Schweikert eventually admitted to participating with the defendant in the killing of Jason Galehouse. In later statements, Schweikert admitted to remaining at 213 Powhatan Avenue all day Saturday, December 20th, 2003. Although Schweikert initially denied knowing about killing the men, later statements, he admitted to participating with Stephen Lorenzo in killing Michael Waccholtz. The state of Florida, in its factual basis, honorably and rightfully acknowledged that the state's star witness made an incredible amount of false statements, not only to law enforcement, but also directly to both Jay Pruner and Esquire from the state's attorney's office, which defense gives them credit for and truly appreciates them admitting to. It's these initial false and untrue statements and denials by Scott Schweikert systemically went from him not only denying and stating that he knew nothing about the deaths of both Galehouse and Waccholtz, or he falsely stated that he was at all involved in playing a part whatsoever, to ultimately admitting to full participation in the deaths of both young men. And anywhere in between, which, when all is said and done, are factually still false and a fabricated lie by the state star witness, Scott Schweikert. What needs to be brought to light is that, as a legal fact, each and every one of the testimonies the defense is aware of, made by Schweikert, that were taken under oath, he had deliberately lied and or made many and multiple false and deceptive statements in an attempt to distance himself and or completely remove himself from having any part or any responsibility with the deaths of either of them. Well, not all of them, because one of them he literally admits to doing it. Like up here, he's like, yeah, I did it. If we go up higher, he admits to doing it. So eventually he does. Including every single one of the sworn under oath state proffers out of the 3 that were conducted by the state of Florida Attorney's Office. Every last one. I have a feeling that's probably not true. When I read all this, like, he'd be able to say, like, see pages like he did it. But I have a feeling those proffers do include him admitting he committed murder. So, not exactly what he's saying. Each and every one of those 3 state proffers, starting from the very first one, and after much prodding by the present Tampa police detectives, and or the present federal agents, including the attorneys themselves, by letting Schweiker know that they did not believe him, or they knew his statement he was making was either false, incorrect, or incomplete, as the next. Then next under oath, Proffer was conducted, and the statement progress were very altered and adjusted from his previous versions under oath Proffer statements, to eventually and finally admitting his guilt or correcting what law enforcement already knew were false statements. It needs to be noted it took the state to have to conduct 3 full separate proffers before it would even accept Scott Schweikert's plea deal. This proves that Scott Schweikert has no problem in committing perjury and lying under sworn oath in a courtroom or otherwise. Now, I'm not sure if that's the case. I would love to see the case file on that, because I get a feeling that's not what happened. Just call me skeptical just a little bit. Just call me skeptical. I'm not really in a position to believe this guy. Not really in a position to believe him fully. I don't think I can believe him, chat. I don't know, chat. Should we believe this guy? So. You mean a murder doesn't fold like a paper bag when under interrogation by the cops? Wow. Yes, I know. So, Toilet Texter says, "I trust your judgment, Sean." Well, in that case, I think you know what? He's probably credible enough. But no, I'm just kidding. No, this guy's just insane. Therefore, it should always be alarming to this honorable court that way back in 2005, Scott Schweiker continued to deliberately commit perjury by making these same false, calculating, and deceptive untrue statements, even more so back then, while under a sworn oath in front of a federal grand jury. The same federal grand jury that ultimately indicted and handed down an indictment against the defendant. It should also be noted that back in 2005, he truly believed that if he cooperated with law enforcement by giving them a false story, but one that fitted the premise of what they wanted, that he would walk and not be charged, where even at one point, law enforcement allowed Scott to return back home to Illinois for an extended period of time. Therefore, he fabricated not too well thought out story, removing himself for completely any wrongdoing. One he has now stuck with. So there's more credibility here. Excerpts from the plea agreement. My God, this is just... This guy is just something else, chat. This is just something else, chat. I love he's so mad, and he's like, this isn't happening that way. We didn't agree to this. It's like, bro. Like, what the fuck is... I don't know. I don't know why he's... I just don't fucking get it. I just don't... Where's J-Rock missing a great stream? Yeah, I don't know. He's out doing family stuff, probably. Janet Morgan saying, that's not true. Yes. Yes, we are J-Rock's family. Yes. It's all about family. Oh. So, Section 4B. online and in personal communication, Stephen Lorenzo and I developed a plan to meet single gay men and take them to Stephen Lorenzo's Tampa home and make them permanent slaves. Our plan contemplated that Lorenzo and I would subject these permanent slaves to bondage and torture and sadomasochism for an indeterminate period of time until we tire of them. Once we became tired or bored of them with a permanent slave, Lorenzo and I would either sell the permanent slave to another practitioner of homosexual sadomasochism or kill the permanent slave. He's not really a permanent slave if he's not around forever, so he's like a temporary slave. Once Lorenzo showed me a video recording that depicted Lorenzo sadomasochistic sexual torture of a man that he had rendered unconscious by surreptitiously administering GHB to him. Now, this is the co-defendant's statement here. We met Jason Galehouse. Lorenzo told me that he would like to take Jason Galehouse as a permanent slave. Mr. Galehouse agreed to go home with us to engage in sadomasochistic sexual activity, but was not aware that Lorenzo wanted me to make him a permanent slave. At Stephen Lorenzo, Mr. Lorenzo and I bound Galehouse's limbs to a bed with restraints. While Mr. Galehouse was bound to the bed, I engaged in sadomasochistic sexual activity with him. I stopped after several minutes and went to the bathroom. Lorenzo took my place on the bed and continued to engage in sexual or sadomasochistic activity with Galehouse. Upon returning from the bathroom, I saw Galehouse struggling with Stephen Lorenzo as Lorenzo choked Mr. Galehouse from behind by applying a sleeper hold. In a May 2005 interview with detectives, I admitted that during the struggle at Lorenzo's direction, I threw my body over the top of Galehouse's legs to stop him from kicking Lorenzo. Galehouse soon stopped struggling and died. After Galehouse's death, Lorenzo told me that it was something that he always wanted to do. You know what it's like to kill a man? You know what it's like to watch a gladiator movie and kill a man. Details matter, yes. So, yes, have you ever been in a Turkish prison? Yes. Now, the second one, we met Michael Waccholtz at a nightclub. Lorenzo told me he had GHB and wanted to use it on Michael to make him a permanent slave. In the living room of Lorenzo's home, I saw Waccholtz and Stephen Lorenzo struggling on the floor. I jumped in, threw my arms around Waccholtz's arms and waist and held him down. Stephen Lorenzo sprayed maximum impact on a rag and covered Mr. Waccholtz's mouth with it until Waccholtz stopped struggling and lost consciousness. While Waccholtz was unconscious, I placed duct tape over his mouth and helped Stephen Lorenzo remove his clothes and bound his arms and legs with handcuffs using the weight of his entire body. Lorenzo then held Waccholtz down on the floor, and Lorenzo mounted Waccholtz and rubbed his genitals against him while telling Mr. Waccholtz, "I'm going to make you mine. I'm going to keep you. You're not going anywhere." Waccholtz stopped struggling and died on the living room floor. Sounds like he positionally asphyxiated that guy. So. Oh, too much details. That's a shame saying, wait, is this the same story as before? So no, this is the co-defendant's story about what happened. This is the co-defendant saying how these guys died. So before it was the defendant's version, now it's the co-defendant's version. Yes, but it's a different guy here. Florida men, everyone. Yes, Florida. Yes, the cum shine state. Maximum impact. Do I dare ask what the fuck that is? No, I don't necessarily think we need to know. That's a shame. Yeah, 2 guys, 2 nights in a row. Yes, they killed a guy one night, then they tried to double their luck. Neither Galehouse nor Waccholtz agreed to become sex slaves for the rest of their lives. And he calls it the reality check. Review Section 4B. No plan was ever devised by either Scott Schweiker nor the defendant to permanently keep the sex slaves for an indeterminate period of time, especially after that full weekend of December 2003. A plan would have had to include going where this permanent sex slave was going to be permanently housed without anyone finding out, which also needed to include now having to plan and arrange as to who and when was going to be able to watch over our permanent slave. So he's like, see, we didn't do anything wrong. I would have had to have had a dog sitter and everything. And to feed and maintain his basic needs. Nor did the defendant even have a clue about how to even attempt to sell a so-called sex slave, which never came close to being discussed, let alone be believed or arranged by either party. He's like, it didn't matter because we weren't doing any of that. As far as the defendant was concerned, the America Online chats with Schweiker were nothing more than just a part of the normal online bondage sadomasochist role play for him. And it was done for his sake. Since taking a permanent slave was his fantasy, not the defendant's, and never was. And now he's saying, see the thousands of pages of online chats that we had. The defendant never showed Schweiker a video recording of a man that the defendant had rendered unconscious by administering GHB, simply because no one ever existed to begin with. The state of Florida is in possession of the 5 of the only... But you notice he says that it didn't exist, but the next paragraph, the state of Florida is in possession of 5 of the only 6 video recordings that the defendant ever made or was ever possession of that was recovered by law enforcement, and he's saying excluding the one made of Jason Galehouse. So he's trying to say you guys have all of them except the one, and made in the defendant's home. Not one of those video recordings depicted anyone unconscious or not moving around. Oh, I'm sure there's a whole stack of videotapes for this guy. The state of Florida showed no interest in them and chose not to utilize them in this death penalty case. The state of Florida would have believed that any of the videos depicted a crime. You could be sure the state would have brought this forward. Well, maybe. The defendant never told Schweiker that he would like to take either Jason Galehouse or Waccholtz as a personal slave, nor did he have any interest in doing so, even if the defendant ever wanted to do so, simply because he did not have the means and ways to accomplish this, which Scott Schweiker was already well aware of, and which is explained as follows. Defendant at that time that both these deaths occurred had another person who was temporarily staying with him at his home, who was not into sadomasochist bondage, and knew very limited of the defendant's proclivity towards sadomasochism. Note, this individual's name appears in the state's witness list, where the state knows exactly who the defendant is referring to. This male individual, who was only a friend to the defendant, not a lover, was staying with the defendant since at the time he was basically homeless, without a job, and had no place to go. So the defendant allowed him to stay with him at no cost for an indeterminate period of time. So he would not be on the street, where the defendant also employed him in one of his construction businesses he owned. I'm sure he did. He's like, can you build me coffins? Or, hey, you know how to use a shovel. Dig this hole for this body. Since Scott Schweiker was planning on staying over at the defendant's home for the full weekend that both defendants occurred, it was prior arranged that this other live-in person to stay someplace else just for the weekend. The defendant has previously had been arranged with this individual. The defendant picked him back up that Monday and brought him back to the defendant's house. Therefore, it would have been ridiculous for the defendant to have stated a desire to even be able to keep a permanent slave. Ha! Since there was unable to do so without anyone finding out. He's like, yeah, see, even if I wanted to do all this, it wouldn't have worked. My logistics wouldn't have worked out. I couldn't support a slave. You know, maybe even though I would just kill him. Well, I don't know, chat. I don't know. Content says, what can he say except you're welcome? Yeah. Oh. Yes, this guy had a lot of free AOL Internet CDs, I bet. I remember we had tons of those. Why are we talking about slaves all of a sudden? We've been talking about the whole night. Alpha Fox says, my HOA wouldn't allow it. Yes, I couldn't keep my slave farm. Yes, it's sound logic, everyone. Case dismissed. Let it be known that Stephen Lorenzo cares very much about the well-being of permanent slaves. The defendant would like to add to the fact that not only was the defendant, at the time both deaths, running two businesses of his own, virtually and mostly by himself, where he was working over 50 to 60 hours a week, once it understood that the defendant needed to be back on a job the next day. The back apartment attached to the defendant's home was under construction, where the defendant spent additional time each week working on it. To go even further, these construction friends stopping at his we're going to stop here, guys. We're going to stop this paragraph. It's 11 o'clock. We are going to head over to locals, and we are going to hang out and watch the Australian Grand Prix. Yes, and apparently the Russians are making it rain caliber missiles right now all over Ukraine. See, that's a shame's right. Case closed. Done. Dunsky. So, yes, you're going to have to move because, shit, the slaves aren't in the contract for this. Yes. But yes, Ukraine is getting shellacked, and that's part of the plan. So, all right, guys, we are going to head over to Locals. If you guys are new, it's potentiallycriminal.locals.com. And we're going to watch the Australian Grand Prix and have some fun tonight. So, back into Formula One season, guys. So, should be a lot of fun. And I will see you over there. And if you guys use the promo code CRIMINALSWITCHY, you should be able to get in and watch it. If you have any problems, shoot me an email, let me know. Tilly says they were building a dungeon. Yes. And Waxing Miracle saying, fuck you, my off to Sky Sports. Well, remember, ESPN uses the Sky Sports feed, so. And, yes, as the song goes, though, I believe it's time to, play us off, chat. But anyways, guys, we will continue with the slavery tomorrow because, oh my God, there's so much here. Models of planes, esoteric works, and even some trains. Much merriment had while drinking. Yes, it was a fuck pit. Tips on hunting and even talking the law. Switchy, yes, like the automatic Glock switch. Even when they nab you on illegal stops, just cause you did it doesn't mean you're guilty. But please talk to a local attorney. Nope, this is played normal speed. Why, yes, it was. He even knows he's fat. For all this fun and more, there's one place to go. Here on Sean Martin's Anyways, guys, good night. We'll be at this tomorrow afternoon, hanging out and going through it. It'll probably be around 3 o'clock or so would be my goal. And then we'll read through what's left. So thank you again, everybody, and I'll see you over in locals. Take care, everybody. Take care, everybody. Good night.